Hi, Amazona, I see you raised your hand. Did you have a question? Live.
Chairman DeVold, we are live on YouTube. Thank you.
Hi, I've been trying to check in. I don't think you were able to hear me though.
Which matter are you calling in for?
I'm calling in for William McMahon, and my name is Staci Sellers from the Randolph Law Firm.
Thank you.
Thank you.
Okay, let's go ahead and get started. I've got 9 o'clock. We'll call the May 3rd Nevada Tax Commission meeting to order. Tina, would you mind calling roll for me, please?
Yes. Commissioner Lippman.
Present.
Commissioner Bursey.
Here.
Commissioner Brown.
Present.
Commissioner Johnson. Commissioner Johnson?
Yes, can you hear me now?
Yes, thank you.
Oh, thank you.
Commissioner Wren.
Present.
Commissioner Rigby.
Present.
Commissioner Witt.
Present.
Chairman DeVold.
Present. Before I start with public comment, I'd like to introduce Stan Johnson as our newest commissioner appointed by Governor Sisolak. Commissioner Johnson, do you have maybe a couple of minutes to kind of tell us about yourself, and welcome to your first Nevada Tax Commission meeting.
Well, thank you very much. Honored to be here with you, to serve with you on the tax. I was born in Las Vegas, Nevada, born and raised there, went to high school down at the old Las Vegas High School. Later left, attended Brigham Young University, obtained a degree in business administration there. Went out in the real world for a few years, worked with a couple of different businesses in the financial and tax area. Then went back for a law degree, also at Brigham Young University. Then moved back here to Clark County, and I've been here since 1986, practicing law since then. And raised my family here. I have 5 children. They're all grown out on their own, and it's been a great place for us. Nevada's been very good to us, and I appreciate being able to serve with all of you. Thank you.
Thank you, Commissioner Johnson. Welcome aboard again. Okay, let's go ahead and get started with public comment. Anyone that would like to provide public comment, please dial *9 to be placed in the queue. Phone number with the last 3 digits would be able to provide comment. And Tina, if you wouldn't mind unmuting people as they want to provide public comment. So again, *9 if you would like to provide public comment at this time. Again, public comment is for items that are not on the listed agenda. So please refrain from commenting on items that are on the agenda. Go ahead. Tina, is there any public?
This is Tina Padovano. I do not see any public comment.
Okay, very good. Director Young, would you administer the oath, please?
Yes, good morning, Melanie Young, Executive Director. The oath will be provided today. By your mere testimony today, you are swearing to tell the truth in your proceedings here today. Thank you.
Okay, very good. Meeting minutes. I'd like any items that we need to adjust on the March 8th minutes for the Nevada Tax Commission, or is there a motion to approve those minutes?
Commissioner Brown, I'd move to approve.
Commissioner Witt, second.
Okay, I've got a motion and second to approve the minutes of March 8th. All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, very good. Next item on the agenda is the consent calendar. I would invite any of the commissioners to pull items that they would like to have further discussion on. And I'll start with item 3E, Motor Coach Industries, Inc., to pull that item. Is there any other items that any commissioners would like to pull for further discussion?
Mr. Chairman, Commissioner Brown, I'd like to pull item 3B as in boy 27, and the item is 24/7 Inc.
Thank you, Commissioner Brown.
Thank you.
Any other items to pull from the consent calendar?
Mr. Chairman, this is Commissioner Rigby.
Yes.
I would move to approve the consent calendar with the exceptions of items 3B 27 and 3E1.
Okay. Is there a second?
Second, Commissioner Bursey.
Okay, Commissioner Bursey seconds. All those in favor, please signify by saying aye.
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 Is there any commissioners opposed? Okay, very good. The consent calendar is approved. So to assist those to get on with their day, if you're under the consent calendar, items 3, A, B, C, D, E, F, you are free to leave and carry on with your day, with the exception of those items that were pulled. So I'll let anybody that plans to leave go ahead and do that now. Okay, Commissioner Brown, item 3B 27.
Thank you, Mr. Chairman. I appreciate that. I don't have a problem with item 3B 27, but I do have a comment, and that is on the briefing document. It indicates that I believe it indicates that it's a portion of the penalty and interest that's been paid. But when I add the numbers up for that, it looks like they've paid 100% of the penalty and interest. So I don't know if the department can speak to that or not, or if it's just a typo on the briefing document.
Is Jennifer Lewis on the phone or on the call?
Good morning, Chairman and Commissioners. This is actually Jennifer Roebuck, the tax manager for the department. I'm currently filling in for Melissa Gardner, who is on leave today for her voluntary disclosures. I'd be happy to attempt to answer any questions on that. And it looks like you were looking at a briefing document, Commissioner Brown. Was it the—
Yeah, that's correct. It's on page 223 of the package. What it says is that it indicates the dollar amount that the taxpayer has paid to the department, and it says it's a portion of the penalty and interest. But when I add up the tax, the penalty, and the interest, it comes up to the amount that they paid. So to me, it seems like they've paid in full, not a portion.
Okay, yes, that could be possible. I'd have to actually look at the account to be able to verify that. Would you like me to verify that and get back to you?
That would be perfect. I'm happy to approve it. I just think the briefing document is incorrect.
Perfect. I appreciate that. We'll make any updates needed. Thank you.
Mr. Chairman, I'd make a motion to approve 3B27.
Commissioner Wren, second.
Got a motion and second. All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, item 3B27, 24/7 Inc. has been approved and will be subject to clarification from the department. Okay, the next item is 3E1 Motor Coach Industries. I don't know if Mr. Csoka is available. Is Louis Csoka available in Las Vegas?
Good morning. Can you hear me, Mr. Chairman?
Yes, I can. Thank you.
Well, fantastic. Good morning, Mr. Chairman. Louis Csoka, for the record, on behalf of the department. Relative to this matter, we've also had the taxpayers' representatives, Joshua Hicks and Jordan Goodman. And in the event that this was pulled for discussion, they've asked that they be included in discussions. Okay. So I don't know if they can be unmuted as well. And good morning to you, Mr. Chairman, and members of the commission.
Thank you. Tina, could you go ahead and unmute the representatives for Motor Coach Industries, please?
Yes, Mr. Hickman and Mr. Hicks are both unmuted.
Okay. Mr. Csoka, I'm looking at the combined numbers and what our settlement agreement is. Could you walk me through the strategy and the thought process? It looks like there is a significant discount from the actual tax paid, and the obviously the penalties and interest are gone. So could you walk me through the logic? And I'd be happy to hear from Motor Coach Industry representatives as well. Thank you.
Thank you very much, Mr. Chairman. So this matter involves two entities that are located out of Illinois. They've engaged in sale of large motor coaches through the state of Nevada. They don't have dealerships in Nevada, but these large vehicles were delivered in Nevada to their customers. And subsequently, the documentation that the initial audit provided did not show that the vehicles were actually properly applied for a driveway exemption under the DMV's requirements. Therefore, the department assessed a tax. Now, subsequently through the audit process, the taxpayer was able to provide documentation that showed that in many cases, these vehicles were in fact driven out of state. In fact, almost all cases were driven out of state for California purchasers. But that in itself was not established as required for purposes of the exemption. So there was some argument as to what the DMV actually requires and whether those requirements were met. So there were some legal arguments relative to those issues. And in light of those legal arguments, legal uncertainties, and in order to not have an extended process for this, the department felt it was a good resolution to reach this compromise. The other thing that entered into consideration is I think there was an amnesty period. And that was also, although not explicitly incorporated in the agreement, was certainly also taken into consideration. So both the extended process in terms of having to litigate these matters and the what's going on in terms of the amnesty period and so forth, this was felt that this was a good compromise for both sides, and the department, in fact, wholeheartedly supports the settlement. If you don't mind, Mr. Chairman, I promised the taxpayer that if this is called forward, they'll have an address to talk about this a little bit as well, and then I'll take it back from them if that's acceptable, Mr. Chairman.
Yes, thank you.
Thank you.
Thank you, Chair DeVold. This is Josh Hicks speaking with McDonald Chrono on behalf of MCI Sales and Service and Motor Coach Industries. And also on the line is Jordan Goodman, who is with Horwood, Marcus, and Burke. And we are local counsel, and Mr. Goodman is lead counsel. So I'd just like to make a couple comments. I'd like to start first off, not related to this, but welcome Commissioner Johnson to his first meeting on the Tax Commission. I look forward to seeing you on the commission in the coming years. But with respect to this case, I would certainly agree with Mr. Csoka's characterization of it. This case actually began quite some time ago. The deficiency notices were issued in May of 2019, so almost 2 years ago. And this case has a lot of complications to it, both legal and factual. And Mr. Csoka, he correctly characterized that about drive-away permits, about business practices. I think without getting too into the weeds, there were certainly some inconsistencies in how the DMV has addressed this issue over the years, all of which led to a case that had good arguments and vulnerable arguments on either side. So to me, it really was a case that lends itself to settlement. There were probably thousands of exhibits if this had to go all the way through on exhibits as well, that would be in place. So all of that and assessing it led to the compromise we did. And like Mr. Csoka said, even though this is not an amnesty settlement, the amnesty certainly was a catalyst towards thinking about it and getting something resolved. So I would like to thank Mr. Csoka and the department for all the work that they've put in trying to reach a settlement. That we've been negotiating the settlement for many months now, and we're glad we were able to reach a compromise. So with that, Mr. Chair, if you don't mind, I'll turn it over to Mr. Goodman.
Thank you.
Thank you very much, Chairman and board members. This is Jordan Goodman from Horde, Marcus and Burke on behalf of Motor Coast Industries. And I believe both councils have added the correct comments about the issues here. I could get into some granular level detail if you would like. Suffice it to say that this was what I would consider to be a risk of litigation type resolution. For purposes of the exemption, there are certain requirements under Nevada law, which were all met with the exception really of one, which was obtaining in each transaction a certificate of interstate movement, moving it outside of Nevada within 15 days. And that really has boiled down to, from our experience, some inconsistencies in the different offices for Nevada motor vehicles. In some instances, we were able to get certificates. In some instances, we were not. In some instances, they didn't even know it existed. So part of the issue here is an $8.25 certificate that we tried to get, we're unable to, but we've met all the other requirements under Nevada law. We have contemporaneous exemption certificates from the purchasers stating that they are moving this outside of Nevada within 15 days. We have registration and thousands of registrations entitling outside the state within 15 days of purchase. We have not contemporaneous, but subsequent affidavits that we got from many of the purchasers certifying everything that they had given, in fact, was true and correct and was done according to their exemption certificates, which were issued at the time of the sale. We are trying to work with the Department of Motor Vehicles to correct this so that we can have a more streamlined process going forward. And I'm available to address any questions that you might have.
Okay. Mr. Csoka, obviously this is a big delta between the estimated tax and the settlement. And I just want to make sure that we feel comfortable that there is enough gray area, I'm going to call it, with vehicles that were moved out of the state without, they basically pass through the state rather than being sold inside the state. Is that a good statement?
Yes, it is, Mr. Chairman. I would say that in the vast majority of cases, the vehicles, the only act that really occurred in Nevada was the transfer of the vehicle to the purchaser. But these purchasers were essentially California customers that opted for delivery in Nevada. So it was just the incident of delivery in Nevada that triggered the taxable transaction. But on substance, all these purchasers were intending to use these vehicles, and not all, but almost all were intending to use these vehicles in California.
So help me with why were they delivering the vehicles in Nevada in the first place? Why aren't they going to California? Is this a distribution hub in Nevada?
Well, I think we take a different viewpoint as to why that happened, the department and the taxpayer. The department's viewpoint is that the reason the deliveries took place in Nevada is perhaps to not face tax consequences in California relative for these purchasers. But I think that the taxpayer has a different position on that, and you might want to hear from them on that as well. But our position, the reason that it happened is because they were probably, the purchasers themselves were probably trying to avoid the California tax.
Mr. Hicks, could you comment on that for me?
Yes, thank you, Commissioner DeVold. There's a long body of case law and statutory law throughout many states, including Nevada and California, that discuss how sales tax applies when property is being delivered for use in interstate commerce. For example, Nevada has a statute that's really the counterpart of the statute in California, which is 372.258. And it sets forth a test on how a property will be presumed or not presumed to have been used in interstate commerce. One of the conditions in that test, the very first condition, is that the property has to be delivered outside of the state of Nevada. California has a similar rule. So what you see in this case is MCI and Motor Coach utilizing a rule that other taxpayers in Nevada utilize on the other side of delivering property that will be used in interstate commerce out of the state, and then it gets used in a fashion that satisfies the interstate commerce usage, usually for a period of about 12 months. And then under United States Commerce Clause jurisprudence, it is therefore outside of taxation for sales and use tax. So it's a tax planning mechanism. And I mentioned that because it's by no means unusual. It's very common, and states all have these kind of rules on the West Coast.
Is there any other questions from any of the other commissioners?
This is Commissioner Wren.
Yes, sir.
Just a quick question, so I make sure I understand this. It kind of sounds like these are brought through Nevada, transferred within 15 days, and they're making it sound like it's just a simple oversight or mistake of not getting a $8 permit. It seems to me like all permits for the DMV were online. Is that not the case for this type of transaction?
That's correct. They are not available online, certainly not during this audit period.
Okay, so if I understand what you're telling us, if they would have got that certificate, we wouldn't have this $2 million differential that we're talking about.
That's correct. And in fact, to your point, if we had gotten the certificates or able to get the certificates, none of the tax would be applicable. A small percentage, 5%, 2% of the tax would be due and owing, because there were some used vehicles that stayed in Nevada in this audit period, which we have paid to the state of Nevada. There were some minor parts that stayed in Nevada that were not eligible for this exemption, but the bulk of it, to your point, would not be due and owing.
So wouldn't it make sense for Motor Coach, when they realized that this was a problem, to get those permits before they made the transaction?
Yes, unfortunately, in the tax world, we live, we're all history majors. We live in the history. And when they realized that they hadn't gotten these, they thought they had complied with the intent of the law to move this outside the state. They had gotten the appropriate certifications and affidavits at the time of the sale, thought that was sufficient without being able to get the actual exemption certificates. And in part, just so you know a little bit about Nevada law, what's going on around the country, Nevada is a member of the Streamlined Sales Tax Project, which is a project that started about 15 years ago to try to align a number of states into a single taxing system to simplify things, as the name connotes. Nevada was one of the original participants in that. And to be a member of Streamline, you must agree to all the rules that are enforced by all the states, and they vote, and the new issues come up, and they vote as a group to figure out how to deal with certain issues. One of the fundamental and initial points of streamline was that with respect to exemption certificates and proving exemptions, that those would be construed in favor of the taxpayer, that they would look to the facts and circumstances and not necessarily all of the technical and specific requirements. What is the intent of the law and how did you comply with it, as opposed to ticking and tying every I or dotting every I and crossing every T. And I believe the taxpayer at the time said, well, we've done 9 of the 10 things. The only thing we weren't able to get, we don't know how to get it. We don't know how to force Nevada to give these with the getting of the certificates. And at the time it was thought, based upon all the other evidence, the fact that Nevada was a streamlined state, the fact that exemptions were supposed to be construed broadly, taxpayer decision said that's what we're going to do now. They have been, this process has been going on. Again, we live in the past. The process of trying to get certificates has continued. We're working with DMV to try to make this process more streamlined. So this question will not come up in future audits.
Thank you.
Any other questions from any of the other commissioners?
Commissioner Lippman, so thank you for that explanation. And while I do appreciate that in the tax world, we're backward looking, now we're forward looking. So I would strongly encourage you to work with the DMV. And so while this is history and there were traps for the unwary, and this is a generous settlement, as the chairman has indicated, on a going forward basis, I would strongly encourage you to cross every T and dot every I, and do that, before this becomes an issue again.
Commissioner Lippman, very well stated, and I appreciate everything that you've said, and we are working with both my client and motor vehicles to make that happen. Thank you.
I appreciate that very much.
Hey, any other comments or questions? Is there a motion to approve?
This is Commissioner Wren. Mr. Chairman, I would move to approve the recommended settlement for Motor Coach Industries.
Commissioner Bursey seconds.
Okay, just as a clarification, it's Motor Coach Industries and MCI Sales and Service Incorporated, consolidated. Are you both okay with that motion and second still?
Yes, thank you. Sorry.
Okay. Any other discussion? Okay, all those in favor, please signify by saying aye.
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 Is there anyone opposed? Okay, settlement agreement is approved. Thank you to all of the representatives from Motor Coach and MCI and to the department. Appreciate your time and effort and work on this.
Thank you very much, Mr. Chairman, members of the commission.
Thank you, everyone.
Thank you.
Okay, Director Young, the next item on the agenda.
Thank you, Melanie Young, Executive Director. Moving on to agenda item number 4, the Division of Local Government Services. The first item under this topic is A, the consideration for approval and adoption of the 2021-2022 ratio study pursuant to NRS 361.333, and the department has Shannon Silva available. Thank you.
Good morning, Mr. Chairman and members of the commission. For the record, I'm Shannon Silva, locally assessed supervisor. The Nevada Tax Commission is obligated by statute to equalize property under its jurisdiction. There are 2 types of information the commission considers to determine whether property has been assessed equitably. The first comes from a ratio study, which is a statistical analysis designed to study the level and uniformity of the assessments. The second comes from a review to determine whether each county has adequate procedures in place to ensure that all property subject to taxation is being assessed in a correct and timely manner. The department conducts the ratio study in accordance with NRS 361.333. It requires the department to determine the ratio of the county-derived assessed values to the taxable value of property that is determined by the department through appraisals of individual parcels. if the ratio of assessed value to taxable value falls between 32 and 36%, it is in compliance with statute. The ratio study must include the median ratio of the total property within each class of property in each county studied. It also must include two comparative statistics known as the overall ratio, also known as the aggregate or weighted mean ratio, and the coefficient of dispersion or COD of the median, for both the total property in each county and for each major class of property. Statute permits the department to conduct a ratio study each year on smaller groups of counties versus the entire state. The counties reviewed for the 21-22 tax year were Clark, Esmeralda, Eureka, Lincoln, Mineral, and Story counties. For your convenience, in addition to the full report, we have provided you an executive summary of any irregularities. Before we get into the meat of the ratio study, I would like to make some comments related to issues outside of the ratio study report itself. First, I'd like to take you back in time a bit, back to 2018 when we were presenting the fiscal year 18-19 ratio study. The topic was Mineral County, and if you recall, right before the completion of the ratio study, they got a new assessor who sat here not knowing what to expect as I presented the findings to you. Mineral had a myriad of valuation problems and included statutory compliance and violation issues. Despite challenges related to the data system transfer and staffing within the office, with assistance from the department, Lyon and Churchill counties, and quite notably the assessor and staff from Story County, Mineral has come a long way in rectifying those issues. They've put procedures in place, done a lot of training and field work, in addition to a lot of cleaning up of their data so that the new system can perform as intended. Some of the results in this study are still reflective of what was found during the 18-19 study, as the assessor is still working through the last of the reappraisal areas. Speaking of the data system transfers, we next arrive into 2019, and the counties begin to go live with their new CAMA systems. In December 2019, the department lost access to the county's data as ADS went offline. To date, we do not have access to any county data within the state, which has created challenges for the department when troubleshooting causes for outliers and a lot of extra work for the counties, providing us with screenshots or information we would typically obtain unassisted. Currently, 11 counties are using the DevNet CAMA system, and one county has gone live with GSA. And Eureka, who was in this study, has, I believe, either just gone live or will be going live in the spring. And 2 counties are still using ADS unsupported and awaiting their go-live dates with GSA. Just before we started the ratio study, COVID struck and we had to make adjustments to the typical ratio study practices. Because of imposed travel restrictions, we were unable to comply with NRS 360-215 sub 3, which states we must visit the properties within the ratio study sample. Since we were not able to travel, we utilized a free trial offer by Pictometry, which gave us statewide access to aerial imagery from all of their clients. This was the predominant means of inspection used during the normal travel period. Google Earth and available assessor aerial imagery was also used throughout the entire study. However, counties with limited area coverage, low quality imagery, or outdated flyovers made adequate aerial inspections limited or non-existent. Without access to county data systems and being unable to visit the county offices, all data information had to be transmitted by the assessors. This increased the time the assessors had to devote to our study and caused delays in completing our work assignment while waiting for requested information. There have been many changes within the assessors' offices in recent years. So this March, the department hosted a reports class for the assessors and their staff to provide an understanding of how the reports that they provide us are utilized on a state level. They were provided the opportunity to ask questions and have discussions as a group. The department provided new resources to assist in ensuring compliance in the future as staffing changes within their office take place. The statistical portion of the report includes the comparison charts of the median and aggregate ratios and the COD for all properties of all 17 counties over the past 3 years, as required by NRS 361-333. Similar data is shown for the counties in the 21-22 ratio study. The aggregate and median ratios, the COD, and the median related differential are compared across all appraisal areas for each property in the 6 counties. Statistical exceptions are noted on your executive summary. Department findings and recommendations within the individual narratives can be directly linked to the statistical results. The data for the aggregate ratio or weighted mean is shown on page 16. The weighted mean is an average where the value is adjusted to reflect the importance to the whole before the values are divided by the total. All ratios are within acceptable standard range of 32 to 36% for the 6 counties studied for the 21-22 year, with the following exceptions: Lincoln County vacant land, rural land, and total rural property, as well as Mineral County multifamily residences. Aggregate ratios within personal property typically are within acceptable standard range of 32 to 36%. This year, 2 counties fell outside of this range in the following categories: Lincoln County secured personal property, commercial, industrial, secured mobile homes, total secured personal property, unsecured mobile homes, total all property, and Mineral County secured commercial, industrial, and total all personal property. Mineral County ratios were just outside of the acceptable range. The median ratios are a comparison of assessed and taxable value and generally indicate over or under valuation of properties taken as a whole within the entire appraisal jurisdiction. The median ratios is the preferred measure of central tendency. The median ratios for the real property shown on page 16 indicate that the appraisal levels for all classes of properties in the 6 counties are within the acceptable standard range of 32 to 36%. Median ratios within personal property typically are within acceptable standard range of 32 to 36%. However, Mineral County had a median ratio of 38.4 within secured commercial, industrial, personal property. The COD is a measure that relates the uniformity of the ratios. The COD ratios, also shown on page 16, for the 6 counties indicate the ratios for all property and each class of property are relatively uniform, with the exception of Mineral County multifamily residential improvements and all improvements, which are outside of IAAO recommended performance standards as described on page 6 through 7. The median related differential is an indication of whether high-value properties are appraised higher or lower than low-value properties. This particular test is not required by statute, but we use it in conjunction with the other statistical tests to determine if a county has an assessment issue. 3 counties had ratios that fell outside of the 0.98 to 1.03 range in specific property classes. The sample of all properties in each of the 6 counties produced ratios inside the acceptable range. The individual classes outside of range, when analyzed in conjunction with the other statistics, were either deemed not a relevant indicator or are addressed within the other statistical categories. The department would like to make note that 1 vacant parcel in Lincoln County was removed from the sample as properties during the statistical analysis. However, it is reflected within the procedural conclusions and the findings follow. The property was extremely large and exempt from taxation. A 5-year sales analysis and 16-year historical analysis was done for the department. Sales of this size were not available, so a definitive valuation could not be determined. However, a nominal value was indicated in the analysis, which exceeded the value applied by the assessor. The assessor was unable to provide any information relating to how that nominal value was determined. This parcel was one of 3 large properties in the sample. The other 2 generated outliers reflective of the 31% vacant land aggregate ratio for Lincoln County. As stated earlier, the aggregate ratio is the average value adjusted to reflect the importance to the whole, before the values are divided by the total contributory value of the outliers. This one parcel, due to its size and thus high land value, when combined with the sample parcels, created an aggregate statewide ratio of 31.6%. Which is below acceptable standards. We do not believe that this single parcel to be indicative of vacant land sales throughout the state, or that it should have such a severe influence on the state as a whole, and therefore decided to remove it from the analysis as an extreme outlier. NRS 361-333 also requires the department to determine whether each county has adequate procedures to ensure that all properties subject to taxation is being assessed in a correct and timely manner, and to note any deficiencies. Typically, deficiencies we find or recommendations we make can be directly correlated to the ratio statistics. The narrative of each of the 6 counties studied, which include procedures, recommendations, and findings starting on page 25. Recommendations and findings are also noted for each specific county, if applicable, on the executive summary. All real property statistical outliers in Mineral County are related to finding 1 in their narrative. All properties were not properly input into ADS when transferred into what is called the DevNet building manual. And this happened when the data conversion took place. The properties require recoding of small improvements and full re-inspections as they have not been reviewed or properly valued since between 2010 and 2014. They were part of the valuation findings that have carried over from the 2018-19 ratio study. The assessor has been inspecting and revaluing properties in future reappraisal areas in order to complete the project faster. It is expected that all properties will be re-inspected, recosted, and correct within the next year. Real property statistical outliers in Lincoln County are both within the land categories. To provide a high-level explanation for statistical outliers, first is an ag-deferred property that was split in the sample property, and it was under 3 acres when it was created. It was later changed to a higher use. It was not processed in accordance with statute, therefore has not been approved to be receiving the ag deferred valuation. The assessor applied an agricultural value and the department a market value. After informing the assessor of this issue in January, the department received an application in March which did not qualify. The assessor is currently working to correct this and collect deferred taxes due. The second involved large parcel properties which are being valued using nominal value when current sales are available, which support higher land values and indicate the use of a higher nominal value is appropriate. Land in the same neighborhoods also appear to be inequitably valued. While we did not include this in the findings, the assessor was unable to provide support documentation for land values. We recommend the Tax Commission order the assessor to conduct a full land value and sales analysis of parcels over 160 acres throughout the county. Once completed, they would provide it to the department for review. If needed, the department will provide training to assist the assessor. Once values are established, large parcels should be valued according to analysis results. This will also ensure properties are equalized and that the assessor can support land valuations. Furthermore, the department will increase the vacant sample size to specifically include additional larger parcels in the next Lincoln County ratio study. Personal property is not a category that's been problematic in the past. However, where ADS updated the personal property depreciation tables for the assessors, the DevNet requires that the assessors update these tables themselves. Mineral and Lincoln counties were unaware of this, and so all personal property was valued using the unsecured depreciation tables, which caused all secured property accounts to be overvalued. Additionally, in Lincoln County, there's a problem in the system with the depreciation of some of the fully depreciated mobile homes. Rather than fully depreciating them, the homes were depreciating at approximately a 20% higher rate. The department has no possibility of identifying the cause without access to the county data. Lincoln has been in contact with DevNet to attempt to identify and correct the affected accounts. The outliers affecting the median-related differential in Story County are related to the land outliers within one specific area of the county. The assessor felt that with market fluctuations and the in-depth land analysis that is happening in that area during the current fiscal work year, it was prudent to wait and to adjust values until pandemic effects could be better analyzed. There were a total of 8 findings within the 6 counties studied, 1 in Clark, 1 in Eureka, and 3 in both Lincoln and Mineral counties. Clark County's finding was discovered in the system valuation process of multifamily duplex properties. The department was able to work with Clark County and Marshall and Swift to determine the cause, and it has been corrected. The Eureka County finding involves the valuation and reporting of qualified heating and cooling systems. The assessor began to capture exempt and report these improvement types once notified by the department and is updating their records as each reappraisal area is reviewed. Lincoln counties have already been discussed, and the remaining finding in Mineral County relates to incorrect value exemptions and reporting of government entity-owned properties, which are still housed in the DevNet building manual. These will be corrected during the current work year. The assessors have been cooperative and accepting of the results of this study. Most of the findings have been addressed by the assessors and either have been or are in the process of being resolved. While some of our findings may appear substantial, we do not believe that there are any systemic statewide issues that need to be addressed. With the added challenges brought on by COVID, we would like to thank all of the assessors in this study for their added patience and the extra time and effort they've put in assisting us these past 12 months. Without their cooperation, we would not have been able to complete this year's ratio study. If you have any questions regarding any aspects of the report, I'm happy to answer them. Department staff and assessors or their representatives from the counties in the study should also be in attendance today, should you have any questions for them. Thank you.
Thank you.
Mr. Chairman, I have a couple questions.
Commissioner Wren, go ahead.
Thank you very much. Thank you very much, Ann. That was well presented. Mr. Chairman, I think my question is probably for Melanie or Jeff. As all of us know, of the 17 counties, the majority of them utilize the ratio study instead of revaluing each parcel each year. So this ratio study is very, very important. Two of my concerns, my major concerns are, number one, is that why aren't all 17 counties using the same software? And why does the state not have the ability to audit that software?
Thank you, Commissioner Wren. This is Jeff Mitchell for the record. So as to why there's not a standardized software used by all the assessors in each county, really comes down to I guess there's not a law that governs that. These counties are able to go out and choose their vendor for themselves, and economics determines a little bit, as well as preference within that county as to which software they use. As far as auditing, we can physically visit the counties, and the assessors are very accommodating in letting us look at the software when we are there. As far as auditing over the internet, there for a while, for a couple of years, we had access to the ADS system and the ADS system only, where we could access the back end and have read-only abilities to look at kind of the mechanics that were happening there. And when we're talking about loss of access, that's the loss of access that we were referring to, is we no longer have the back end look at a lot of the things, but we still have the front end look through that the normal public has, as well as the ability to travel to the assessor's office and see what's going on with their systems when we're there. And most assessors are also very accommodating. When we have questions, they will send us screenshots or samples of the information that's there. But yes, the access is more limited now, but we also did not have full access statewide to every system ever. I hope that helps answers a little bit.
It does. And you realize, because of my background in equalization, I do worry about this kind of stuff because I spent so many years dealing with it. Is this something that would warrant a workshop looking into to make sure everybody's on the same page? And the thing about using 3 or 4 different softwares, depending on how you do the input, you're going to come up with different answers. And again, because the ratio study is so pertinent to so many of the counties, it just seems to me like everybody should be on the same page. And especially with the smaller counties, the state have the ability to go online, in this day and age, and make sure everybody's doing the same thing. And if there is a problem, like some of the ones that Shannon pointed out, to help alleviate them before they get too far down the road.
Yes, I believe that we could hold workshops, and we do hold workshops and working groups quite often on different questions that arise to try in our best to standardize and equalize throughout all the counties. I know that the assessors that are on the DevNet program, they have a working group that gets together fairly frequently to work through the different issues that are there. The counties that are not on that system are not part of that working group. I imagine they have their own and they coordinate. As you mentioned, it would be a challenge having it is a challenge, maybe I should phrase it that way, to make sure that everyone is on the same page, but perhaps a more standardized working meeting where we address different concerns to make sure that they are compatible and comparable across all softwares would be a worthy endeavor on the department's behalf.
Okay, great. If you and Melanie could look into that, I would appreciate it. Mr. Chairman, that was my last question. I will wait if you'd like. I would make a motion that we require Lincoln County to reappraise their parcels over 160 acres, but I'll wait if there's other questions if you'd like.
Yeah, maybe let's wait on that one. And I kind of understand, during the COVID ages and how strapped all of the county governments have to be. It would be wonderful if everybody could use the same software, but adding another burden on counties right now might not be the best timing, is what I'm thinking. But I think encouraging all counties to use the same software would be a wonderful endeavor, I think. And obviously, those that can afford it, we would probably cheerlead them to do that. So thank you, Commissioner Wren, for that. I want to take time to make sure that, is there any comments from any of the county assessors that are on the line? I see we've got a couple available. If you could unmute those county assessors, Tina, and if there's any questions with any of them, this would be the time.
Lincoln County would like to comment.
Hello. Can
Yes,
you guys
state your name and spell it for the record, please.
This is Lincoln County Commissioner Jared Brackenbury. It's JaredBrackenbury. And my comment is to Commissioner Wren. I do believe that standardizing, having one software for all counties is a great idea. We ran into some real problems with DevNet getting it to align with the ADS system. And we didn't feel confident using it moving forward. So we are in the process of going back into ADS and then moving to GSA. But the software issue for us rural counties, it's a real burden as far as expense, number one, and number two, it's a real burden finding the company that can basically correlate and get everything accurate. We were finding that we couldn't find, accuracy between ADS and DevNet. So it is a problem. I think I really agree that if we could find one system for everybody, it'd be great. But finding that system, we're definitely reaching out. And if there was some help, with you guys to find a system that you guys trusted, it would help us greatly. I also have our assessor, Mark Holt, here too. I don't know if he has any questions or comments for you guys, but he's right here with me.
Yeah, I don't have any comments at this time.
Okay, thank you both for taking the time. Any other comments from any of the other assessors?
Esmeralda County is unmuted. I don't know if they have comments. I don't believe they do.
Okay, can you hear me now?
Yes.
Okay, thanks you. This is Ruth Lee, Esmeralda County Assessor. And when you were talking about conforming, since I've been here for 24 years, I can kind of talk to this. Conforming, ADS never really was conformed either. Each one of us had a different program to begin with. And so there was a lot of challenges with whether the assessor decided to put everything in or not. And with the conversion, if you did not have everything put in correctly, it was never going to convert. We managed to go through and run basically, I know the word 2 sets of books is not a good phrase, but it's true. We ran the ADS, we ran the DevNet. We went through it 7 different times to make sure the tax roll was correct. And we had absolutely no problems with it whatsoever. And our conversion was very easy. And I'm quite satisfied with the results we're getting from it. And probably thank you to Shannon Silva and Jonathan Roberts, who did my ratio study. And I appreciate all their help. This will be my last ratio study as an assessor. And, you know, they did a wonderful job through this whole consistency and the mess and everything else that was going on. But my records are out there on the website completely. We try to be as transparent as we can with anything that we put on the website, so anybody can get anything that is in my office.
Okay, thank you, Ruth. I appreciate it, and hopefully this is a retirement that you will enjoy. So thank you for your service. We appreciate it. Mr. Mitchell, I think, Mr. Wren has brought up a good point. It sounds like if there's some consistency and changeover over time, that workshop sounds like a really good idea to try and gain some consistency, and sounds like it would save time for the Shannon Silvas of the world that have to go out and try and attempt to be reasonable and logical on assessing these. So I would cheerlead you to do that endeavor. So very good. Is there any other questions or comments from any of the other commissioners?
Mr. Chair, this is Commissioner Rigby. I have a comment and a question.
Please.
First of all, Mineral County has come a long way, and I wanted to acknowledge that. I know they've had help from another county, they've had help from the state, and it's just amazing the progress that's been made there. And in the document, it appears that there's some difficulty with transportation, and I'm wondering, just as a question, is there a state pool vehicle that could be loaned to the county while they catch up the remaining appraisals? If that's a possibility, could that be done? And well, let me just ask that question first and see. I don't know if that's a Jeff Mitchell question, or Melanie, I don't know.
I don't know if that's a Jeff Mitchell question either. I would have to look into resources and what we'd be able to do. So I can't make any promises as to a resolution there, but I could look into it.
Thank you. Part of the reason I ask, I know that in the state appraisal work, at least last summer during COVID, has been limited or non-existent, and so maybe there are some vehicles available or some capacity that could be used there to assist Mineral County. And I want to echo some of Mr. Wren's comments. It would be ideal if from your computer in Carson City, you would be able to have an interface where you could see, where you could pull up the other counties. It seems like most are on DevNet, and there's a few others, but if there was a way to build an interface so that you could do some compare and contrast among the counties from your desk, that would be, that would probably have to be written or licensed by DevNet and or probably, or maybe even custom, but that would be ideal if that was possible. I'm not sure if it is. Just throwing that out there. And one last thing, we're going to miss you, Ruth. You've done a great job.
Good morning. I'm not sure if the board can hear me. This is Jana Seddon, the Story County Assessor.
We can hear you.
Okay, I'm going to apologize. I'm in Georgia currently, and we're in the middle of a huge thunderstorm and some tornado watches. So I was a little bit hesitant. If it gets loud, I apologize. I just wanted to, first off, comment to Commissioner Wren's, one of his statements. I was part of that board that was developing the DevNet software. And it was a long process. We did not, you think 3 years would be enough time to find a company and design a software, but our system is a little bit difficult. The Nevada taxing system, because that bifurcated system, it's not like anything else we've done. We basically kind of ran out of time before we went live. We started off with 15 counties. We're down to 11, as you well know. But what I would like to say is the current DevNet counties, we have absolutely no problems allowing the state to have access. At least at this point, we don't want to allow access because it's still a work in progress. There's a couple of areas that we are still rebuilding that we're working, and to allow outside entities to come in when we're still working and changing, I think would be more detrimental to the county, to the Department of Taxation. But we've come a long, long way, and we are very close to getting what we want. Right now, we're in the process of rewriting and reworking the personal property system. For myself, once that personal property system gets in place and it's vetted and we know it's working well, I would have absolutely no problem giving the state access to my information. And I truly believe that the majority of the assessors that are on the DevNet system would feel the same way.
Okay, thank you. Any other comments from any of the other county assessors?
Yeah, this is Kevin Chisholm from Mineral County. I just wanted to give you an update. We were tentatively approved for a vehicle this year, and we have our new appraiser trainee. So I think 2021 is going to be our year. So I just wanted to update you on that. We're getting the tools we need. And I would also agree with Gianna. We have no problems opening up the DevNet system, so that makes the state's job a lot easier once we can get this finished product up and running. Thank you.
Thank you, Mr. Chisholm. Were you one of the gentlemen that grew up in Yerington by chance?
Absolutely. We went to the same bus stop, Jim.
I thought I recognized your name.
Yes, sir. Yes, sir. Good to see you.
Congratulations on your role there, and I was very excited to see your name on the list. So congratulations with all of your success.
Thank you, Jim, and congratulations to you as well.
Thank you. Anyone else?
Yes, this is Jamie Jacobs, Clark County. Can you hear me?
Yes, we can.
Yes, just a couple of comments regarding Commissioner Wren's suggestion. We can certainly look into providing views into our system, but one of the things we have to consider, there are other departments that utilize the same vendor. And so we have to obviously take that into account. To be able to switch to a different vendor might be an uphill battle, but we could certainly look into providing a way, whether we build a web interface, the state could view our tables and that kind of stuff. That's certainly a possibility, or some sort of standardized file format that we provide the data that way. We could certainly do that. And I'd certainly like to thank Shannon for her help in helping me along with our ratio studies. Hopefully I was able to provide everything that she needed. Thank you.
Thank you. Any other comments from any other county assessors?
If any of the other assessors have comment, please dial *9. I do not see any other comment at this time.
Okay. At this point, I've just got a quick procedural question with Deputy Attorney General Boardlove. Do we have the authority to deviate from the Nevada revised statutes where Shannon Silva had mentioned that they were required to go see these items personally, the real estate and items personally? Does the commission have the authority to approve that with these COVID circumstances?
Without, I need to look at that specific statute to give a more thorough answer, but in general, I would say under COVID, you probably could in this situation because there's been a lot of, we have our governor's directives that have been allowing for a lot of leeway in circumstances where we can't. If you want to give me a minute to find the specific statute she's referring to, I can look. In general, I would say you probably do have the ability just for this one circumstance or to direct there to be in the next year some amount of redoing, going through it once it's safe again. But seeing as it was not safe to do the physical visits over the past year when that was done.
Okay. Yeah, I would appreciate just some cover. Like I say, I hate deviating from the statute. It looks like it's NRS 361.333 was what she was quoting. But, I just want to make sure that we're not overstepping our bounds here. So thank you. And I'm sorry, I'd like to return. Is there any other questions from any of the other commissioners at this time? Commissioner Wren, I'll return to you for the motion then.
Thank you very much. Two things first, Jeff, when you do your workshops, you might have to talk to the state and see if there's monies available to help the counties financially if we need to. If, the state says counties go do these ratio studies, and if they need some help financially, maybe we need to look into that. And I have been in contact with the Esmeralda County commissioners, and Ruth, you don't get to retire, sorry. Okay, so Shannon, make sure I do this right. What you've asked is for us to have Lincoln County reappraise all parcels within their county over 160 acres. And I believe you said within the next year, is that correct?
Sometime within the next year, between the next year and the start of their next ratio study.
Okay, so that would be my motion is to require Lincoln County to reappraise all parcels larger than 160 acres between now and the new ratio study.
And are you also recommending approval and adoption of the 2021-22 ratio study?
Yes.
Okay, so we'll amend the motion to include that. Is there a second to that motion?
Mr. Chair, this is Commissioner Rigby. The order to Lincoln County isn't agendized. Is that a subset of approving the study, or do we have the authority to order that without it being on the agenda as a specific item?
That's a good point. I don't believe we do have the authority to do that. I think, Commissioner Wren, could you amend your motion and recommend rather than have it, have it in the meeting minutes?
Yes.
Recommend that we do that.
Yes, sir. And I agree with that, Mr. Chairman. So my motion is to approve the adoption of the 2021-2022 ratio study and to recommend that Lincoln County reassess their parcels over 160 acres between now and the next ratio study.
Thank you. Is there a second?
Commissioner Rigby, second.
This is why I enjoy having attorneys on this tax commission. Thank you for keeping us on the straight and narrow. All those in favor, please signify by saying aye.
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 Is there anyone opposed? Okay, the ratio study for 21-22 has been approved. Director Young, the next item.
Thank you. The next agenda item is the discussion in consideration for the approval of the 2022-2023 improvement factor study pursuant to NRS 361.261 subsection 2, and the department has Cheryl Erskine available. Thank you.
Good morning, Mr. Chairman and members of the Commission. For the record, I'm Cheryl Erskine, Coordinator of Assessment Standards for the Local Government Services Division. This morning, I'm appearing before you to request adoption of the 2022-2023 statewide improvement factor of 1.01, as indicated on page 1 of the improvement factor report. The purpose of the improvement factor is to keep properties that are not reappraised annually at a similar level of assessment with properties that are reappraised each year. Typically, reappraised properties reflect the inflationary trends affecting new construction, as reported by the Marshall and Swift Costing Service. NRS 361.261 gives the assessors the opportunity to notify the Commission that they either approve or object to the improvement factor. This must be done on or before May 15th. This year, the assessors all responded very timely, so we're bringing this before the Commission now instead of after May 15th. The assessors all either approve the improvement factor and apply it to the improvements not recost that year, or they recost all improvements annually and don't use the factor. The assessor approvals start on page 50 of the 2022-2023 improvement factor report. Currently, 2 of the 17 counties use the improvement factor. I'd be happy to answer any questions you may have. Thank you.
Thank you, Ms. Erskine. Was there any disagreement with any of the?
No, there was not any disagreement. They all approved it.
Mr. Chairman, I have a question. This is Commissioner Rigby. A question for Ms. Erskine. On it looks like about 3 of the assessors made no choice whether to accept or reject on their form. When they're given that option and then they don't make a choice, is there any legal effect to that, or is there any consequence for that? Is it just an oversight?
When I spoke to most of the assessors that do not indicate approval or objection, it's because they recost each year, so they didn't feel that approval really applied. So I'm not sure what recourse we have in getting them to indicate that if they choose not to.
Would it be possible to add a third option on there that that we recost each year, so therefore we don't need to accept or reject? I mean, is there like a way to make that more clear for the commissioners?
I can definitely do that, yes.
Thank you.
Okay, any other questions? Is there a motion to approve?
Mr. Chairman, Commissioner Rigby, I would move to approve the 2022-2023 improvement factor study.
Commissioner Witt, second.
Okay, I've got a motion and second. All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, Director Young, next item on the agenda.
Thank you, Melanie Young. For the record, moving on to the next agenda item, which is agenda item C, the discussion and consideration for the approval of 2022-2023 personal property manual as authorized under NRS 361.261 361.227 and NEC 361.1365. And the department has Jeff Mitchell. Thank you.
Good morning, Mr. Chair and members of the commission. Jeff Mitchell for the record, Deputy Director of Local Government Services. As mentioned before you today is consideration and approval of the 2022-2023 Personal Property Manual. Nevada Revised Statute 361.227 sub 6 assigns the Nevada Tax Commission the responsibility of establishing standards for determining the replacement cost of various kinds of personal property. These standards and methods of valuation are contained in the Personal Property Manual that is before you today. The Personal Property Manual provides 10 different percent good tables, including tables for a 3, 5, 7, 10, 15, 20, and 30-year expected life, and tables for mobile homes and billboards. There is also a special property section listing recommended life expectancy for certain specialized equipment. The department, by regulation, is required to hold a workshop every year before this is presented in front of the Tax Commission. The department held this workshop on April 8th, 2021, and has held open the comment period to receive public comment. At that workshop, we present market studies to both the assessors and to industry, which shows our due diligence when we compare different properties when applied with the Personal Property Manual to make sure that they do not exceed full cash value. The market studies indicated that there was not a problem with any of the life tables, that the depreciation brings property underneath what is considered full cash value. We did receive public comment at the workshop seeking clarification on some of the definitions that are stored within the special purpose properties, as well as clarification if we could provide examples of how to apply certain obsolescence within the manual. We believe that these are worthwhile considerations, but we would like to take a very transparent and thoughtful approach to this. So for the manual this year, we are seeking approval as is, but we are intending to conduct workshops this fall to look at revising some of those definitions, as well as providing different examples going forward. And so we are hoping to revise the manual in coming years, but we would seek approval of the manual as is for today. And with that, I am able to answer any questions that the commission may have.
Thank you, Mr. Mitchell. Any questions from any of the Tax Commission members?
Mr. Chairman, it's Commissioner Brown. I don't have a question, but I just would like to make a disclosure that the manual includes telecom and ISP equipment. It doesn't affect my employer any differently than any other telecom or ISP provider. So I will be voting on this, but wanted to make that disclosure.
Thank you, Commissioner Brown. Any other questions of Mr. Mitchell? Is there a motion to approve?
Mr. Chairman, it's Commissioner Rickey. I would move to approve Bulletin 211, the 2022-20. Oops, I'm sorry. Let me back up. I would like to approve the 2022-2023 Personal Property Manual.
Commissioner Lippman seconds the motion.
I've got a motion and second. All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, very good. Director Young, next item on the agenda.
Thank you. Moving under the last agenda item under this topic for local Division of Local Government Services. This is item D, the review and consideration for adoption of Bulletin 211 for the 2022-2023 agricultural land values and open space property procedures as authorized under NRS 361A.140 and NRS 361.325 subsection 1B. And the department has Cheryl Erskine available. Thank you.
Good morning, Mr. Chairman and members of the commission. I am Cheryl Erskine, Coordinator of Assessment Standards for the Division of Local Government Services. This morning, I'm presenting the 2022-2023 Agricultural Land Values and Open Space Property Procedures for your review and approval. Page 8 of the document reflects the proposed value per acre for each land classification, as well as the adopted values for the preceding 4 years. Each year, we send a hay survey out to agriculturalists in our state and compare it to the Nevada Agricultural Statistics Service prices, which you can find on page 19 of the document. This year, the survey was sent to 947 agricultural properties. 68 were returned with no information provided, had sold, or for various reasons were deleted from the database. 147 were returned and provided information relating to the price per ton of alfalfa hay and estimated tonnage produced, as well as information regarding wild or other hay, watered pasture rental prices per AUM, and grazing rental prices per AUM. Intensive use and cultivated land increased 3.5% over last year, while native meadow land increased 2.2%. Pasture land increased 1.3%, and grazing land experienced an average 0.07% decrease. This year's median price plus the previous 4 years' median prices are used to calculate the current price. You can see these calculations on pages 9 through 14 of the document. I'd be happy to answer any questions you may have. Thank you.
Thank you. Any questions of Ms. Erskine? Is there a motion to approve?
This is Commissioner Witt. I would move to approve the Bulletin 211 2022-2023 Agricultural Land Value and Open Space Property Manual.
Commissioner Bursey seconds.
Got a motion by Commissioner Witt, seconded by Commissioner Bursey. All those in favor?
Aye. Aye.
Aye. Anyone opposed? Okay, the bulletin is approved. Director Young, next item.
Thank you. We are moving on to agenda item 5 for the compliance division. The next is agenda item A, the taxpayer's appeal of administrative law judge decision pursuant to NRS 360.245 and NAC 360.175. The department, the taxpayer is Blow Smoke Shop and Gift Shop, or let me restate that, Blow Smoke and Gift Shop, LLC. And the department has the Attorney General's office, Elizabeth Hickman, available. Thank you.
Tina, is there someone from Blow Smoke and Gift Shop on the telephone?
Yes, Eve Morrill appearing for Blow Smoke and Gift Shop LLC, and its principal Wahid Aziz.
Could you state your name and spell it for the record again? I'm sorry.
Eden Morrill, and that's spelled E-D-E-N as in garden, last name Morrill, M as in Mary, O-R-R-I-L-L.
Okay, thank you, Ms. Morrill. Go ahead. This is your appeal of the administrative law judge's decision. Go ahead and make your case, please.
Thank you.
Thank you.
With the shutdowns, quarantines, along with many taxpayers, the IRS, Treasury Department, in response to the global COVID-19 pandemic, took unprecedented action to extend a wide variety of filings and payment deadlines. Included were types of waivers, including the failure to file, failure to pay, penalties for millions of taxpayers affected and working through the challenges created by coronavirus. Of course, this includes waiver of civil penalties. The IRS first time penalty abatement was a solution for many taxpayers who had never found themselves in such situations. As the Department of Taxation is aware, every taxpayer is entitled to request abatement of penalties for they have reasonable cause. Along this line, due to the incredible amount of unforeseen circumstances encountered, a custom penalty abatement form was designed to request a reasonable cause penalty abatement, and many civil penalties have since been waived, including those assessed by the Department of Taxation. Pursuant to the underlying matter, while Blow Smoke contends errors were made by it in or about January 2020, previously since commencing operation, this has been its first time. Subsequent to this wrongdoing, Blow Smoke has initiated a second authority compliance review to avoid such from happening again. Accordingly, and based upon financial hardships Blow Smoke has sustained pursuant to the pandemic, along with business damages it has recently suffered as a result of a broken water pipe at its business location, Blow Smoke graciously requests exoneration or waiver of the 2,000 civil penalties assessed it in connection with its first time compliance failure of January 2020. Thank you.
Thank you, Ms. Morrill. Is there let's see, Elizabeth Hickman with the Attorney General's office available for comment?
Good morning. Good morning. This is Elizabeth Hickman.
Go ahead and spell your name for the record, please.
Elizabeth is Elizabeth. Last name Hickman, Hickman.
Thank you.
Thank you. Sure. In accordance with NRS 360.245 and NAC 361.75, to have the determination of the ALJ modified or reversed, Blow Smoke would have to demonstrate that the ALJ's decision was in violation of law, in excess of statutory authority, or affected by other error of law. Although sympathetic to the difficulties the pandemic has placed on virtually all businesses over the last year and other difficulties this taxpayer alleges, Blow Smoke cannot demonstrate any error of law or arbitrary or capricious determinations in this case. Prior to the pandemic, Blow Smoke was found in possession of and distributed OTP that was not purchased from a licensed wholesaler. This product was not tax paid. Additionally, Blow Smoke failed to maintain proper records for this OTP that was in their possession. Therefore, the civil penalties that were imposed should be affirmed.
So, Ms. Hickman, just so I've got this correct, really, this is not a COVID-related issue. This is an issue that they were selling other tobacco-related products that were unlicensed, or maybe clarify that for me. I apologize.
Sure, that's correct. This taxpayer in late 2019 was found in possession of OTP that was not purchased from a licensed wholesale dealer. Therefore, the OTP was not tax paid. So the underlying transaction and the ALJ hearing all occurred prior to the pandemic. The pandemic certainly led to the delay in this matter being appealed and brought before the commission, but it had no bearing on the underlying offense that led to the civil penalties.
Okay, thank you. Ms. Morrill, do you have a response to that?
Well, I understand that the pandemic hadn't occurred, and I didn't refer to the pandemic previously in 2019. I'm talking currently the financial problems that Blow Smoke is currently experiencing. And furthermore, not that it means anything under the statute, but the cigars were not being sold, they were being handed out. And I do understand the wording of that statute, however.
Okay, thank you. Is there any questions from any of the commissioners of the department or the taxpayer at this time?
Commissioner Rigby has a question.
Please.
And this question is for Ms. Hickman. The state could have revoked the license, but for blow smoke, and chose not to, and assessed a penalty of $2,000 without revoking the license. Is that correct?
That's correct. On a first offense such as this, the taxpayer has 10 days to explain how they're going to prevent any further violations of the same statute before the license is revoked. So that process did not move forward beyond that.
Thank you.
Commissioner Lippman has a question for Ms. Hickman as well.
Please.
So it seems to me that the liability issue is different than a hardship issue. And because of COVID, now this arguably has become a hardship for blow smoke, but that can be that's handled separately from the liability issue. Would you agree with that, Ms. Hickman?
I would agree. To the extent any negotiations would happen between the department and the taxpayer, that would be independent of what's before the commission right now.
So at this point, blow smoke, unfortunately, this is a penalty that's consistent with the law and consistent with the facts that issue at that time. But subsequent, as you've indicated, COVID-19 has hit the world. And so that perhaps is a separate hardship issue that I would encourage you to reach out to the Department of Tax to try to address.
Thank you.
Mr. Chairman, I have a question. Would it be within our authority to approve the administrative law judge's decision, but split the penalty 50% in recognition of the hardship they're experiencing?
You know, without really knowing a ton of the facts related to their financials, I'd almost rather have them do an offer and compromise route, if that would be acceptable. Are you okay with that strategy rather than deciding what it is? You know,
I would agree to that, except that it's such a minimal amount. It would take more time and personnel than it would warrant to make essentially a $1,000 waiver.
Go ahead and make a motion, and we'll see where that lands then.
Okay, I would move to uphold the administrative law judge's decision with regard to Blow Smoke and Gift Shop LLC, with the caveat that I would reduce the penalty from $2,000 to $1,000 in consideration of current COVID hardship.
Mr. Wren, I will second that, but I also have a quick comment. I just wanted to point out, in looking at this case, looking at the pictures, their argument is that they were given away free. But if you look at the pictures, they all have prices on them, and I don't see free any place. However, I do agree with Commissioner Rigby's motion and do second it.
Okay. So I've got a motion and second. Is there any other discussion on this item?
Commissioner Lippman is going to suggest that we go through the traditional process, because arguably the financial data could indicate that Blow Smoke is in such a precarious position that the entire amount should be waived, maybe down to, I do offers and compromise with the IRS of $1. And so I would suggest we go through the proper procedure rather than equitably try to adjust this. And that's the way I'm going to vote.
Okay. Why don't we go ahead and go through a roll call vote on this one. Commissioner Wren?
Aye.
Commissioner Brown?
I would just make a quick comment, Mr. Chairman, before casting my vote, and that is, I agree with Commissioner Rigby that in order to conserve the department's resources, it seems like a prudent way to proceed for such a small dollar amount, and I'll be voting yes.
Thank you. Commissioner Rigby?
Yes.
Commissioner Lippman,
No.
Commissioner Witt,
No.
Commissioner Bursey,
Yes.
Commissioner Johnson.
Yes.
The ayes have it. So the penalty is reduced to $1,000. And thank you to Ms. Morrill and to Ms. Hickman. Next item on the agenda, Director Young.
Thank you, Melanie Young, for the record. Moving on to agenda item 6, which is informational items. We have 2 topics under informational items. Item A, which is the penalty and interest waivers granted by the department for sales and use tax, modified business tax, and excise tax, as well as item B, the approval and denial status report log for organizations created under religious, charitable, or educational purposes. And if it's all right with the chairman, I will move on to the executive director briefing.
Is there any questions on any of the informational items? Okay, very good. Go ahead, Director Young. Thank you.
Thank you again, Melanie Young, for the record. We'd just like to share with the commission, the department has been very busy this legislative session. On May 1st, which was Saturday, our budget was presented to the full committees on Assembly, Ways and Means, and Senate Finance for closing. And we have presented in Senate Finance for SB 414, which is a one-shot appropriation for our system modernization, and SB 415, which is our office consolidation in the Las Vegas area, as well as SB 416, which is our computer and printer replacements. Those are all one-shot funding and outside of our budgetary process. As well as AB 9, which was the department's policy bill, which would allow the department to share taxpayer information to the governor's finance office for revenue projections, has passed, been enrolled, and signed by the governor. SB 25, which makes revisions to the definition of prepared foods, and SB 74, which revises the population utilized for tax distributions, have been heard in both houses and will be moving forward to be finalized. We have 3 items that are still pending introduction at the legislature. The first one is BDR 1077, which will create an annual seller's permit fee. And these 3 items, before I go into detail on them, they were all budgetary requests to prevent having to do budgetary reductions. So the executive team put together some revenue proposals so that we didn't have to reduce additional staffing. So the first one again was BDR 1077, which will establish an annual seller's permit fee of $15. Currently, that $15 fee is a one-time fee. Then we have SB 423, which will set a budget to reimburse the department for processing centrally assessed property tax. And then finally, BDR 1079, which will increase the justice court fee from $1 to $2 to cover the cost of the state demographer. The department is following several large tax bills that could be implemented this session. The first one being SB 389, which would implement a new excise tax for peer-to-peer car rentals. Following SB 346, which is a digital products excise tax, as well as SB 281, which would impose a excise tax on the retail sale of hemp or CBD products. This final month of session will be very busy for the department while we work through these bill hearings. Moving on, the department is working on its return to normal work plan. The provisions of having our tax commission being handled remotely will end June 1st. So our next tax commission meeting on June 25th will have a physical location in the Carson City office. Some of the tax commissioners may still wish to attend remotely, and we can accommodate that. We have several major staffing changes within the department. Jeff Hardcastle, the state demographer, has announced his retirement, and he will be retiring at the end of June. The executive team interviewed and recruited for the position and has offered the position to Matt Lawton, who will be starting next week. Fortunately, Matt will have an opportunity to work with Mr. Hardcastle through his retirement at the end of June. Also, I'm saddened to share that Kanaya Vadalacunta has announced that he has accepted a position with the City of Reno. Kanaya has been in the position of Deputy Director for IT for about 5 years. Currently, or pending the recruitment and filling of this position, we are very fortunate that Joe Bernardi has accepted the role of Acting Deputy Director for this position, as well as Deputy Director Dave Prather for the administration will be on leave for an extended period of time. Until his return, the rest of the executive team will be sharing the duties of the Deputy Director position for administration. And that concludes my presentation, and I'm available for questions.
Any questions? Director Young, thank you for all of your efforts during this legislature. It can't be easy right now. I'm sure it's very, very difficult. So we appreciate your time and effort of you and your entire staff. Thank you. Okay, our next meeting is June 25th. It will be in person, and Director Young will let us know where we will go for Las Vegas and Northern Nevada meeting space. At this time, is there any public comment? Again, please dial *9 to raise your hand, and we'll recognize you for public comment.
Chairman DeVold, I do not see any public comment.
Okay, very good. Thank you. Are there any items for future agendas that we haven't covered already in the meeting? All right, very good. We'll stand adjourned, and I'm looking forward to seeing everybody in person at the next meeting. So thank you, everyone. And again, as Director Young had mentioned, if you're uncomfortable, please continue to call in. But I'm excited to see people in person rather than on a flat screen. So anyway, thank you all, and have a good rest of your day. Take care.
Thank you.
You too. Bye-bye.
Thank you.
Thank you, Mr. Chairman.
Peace.